Okay, welcome to Borderlines. We are recording this on November 8th, 2024, and our guest today is Andrew Mattu, who is the founder and principal of Godwit Law Office in Brampton, Ontario. Andrew, thanks for coming on.
You're welcome, Stephen.
Yeah.
And Andrew, we should let you introduce your colleague as well. We forgot to.
I am being accompanied by Ajaypal Singh. Ajaypal Singh recently got called to the bar. Ajay has been with me for the past 3 years now. So Ajay assisted me with one of my federal court cases on restoration recently.
Yeah,
Pleased to
and
have
that
you
was a
also,
case,
Ajay.
Tour v Canada, which,
Yes.
oh, they're welcome, by the way. Congrats on getting just called to the bar.
Hello, everyone.
Yeah. So in a previous episode where we discussed, I think we called it the top cases from either August or September 2024, we talked about that case,
Right.
Tour v Canada, and Andrew reached out after, because Deanna and I speculated a bit on what might happen on redetermination, and Andrew reached out to say that he listened to the episode, enjoyed it, and that we should do a whole episode on just this topic, which is a growing topic and one which may continue to grow after the
Unfortunately.
US election results, where people are speculating that there may be a lot of migration to Canada, of options for people who are inside Canada without status. And we're going to focus on, or at least our plan, we'll see where the conversation takes us, is to focus on the two operations, or the two applications that can get someone temporary status or permission to stay in Canada on a temporary basis. That is a restoration of status application, as well as a temporary resident permit. Depending on the time, we may get into permanent residence applications as well, or we may save that for a future episode. Before we get into the ways that people can restore their status or get a temporary resident permit, why don't we just give some examples of how people may find themselves without status?
Hmm.
I don't know if Deanna, you want to take the lead, or Andrew, like what are the ways that people may
multiple
find
ways.
themselves without, right? Like I think people may have the sense of, oh, they're just people who like stayed here with no intention of ever extending their stay. They're here illegally. But what are some ways that people find themselves without status?
Stephen, one of the main reasons that I'm finding right now, and I'm getting a lot of consults regarding that. So the visa stamp on the passport, if it's for 10 years, people who come inside, they think that they are allowed entry for 10 years.
Hmm.
On the contrary, the entry for a visitor visa is just 6 months if it's not stamped by the officer.
Mm-hmm.
Most of my clientele is like, oh, we have a 10-year visa, we could stay here for 10 years. So that's reason number one, I feel.
Mm-hmm.
Reason number two is the same, but let's say someone who's on a PGWP, he got a 3-year work permit. Now they apply for a TRV, stamping of the passport. So the TRV is stamped for like 6 years, 10 years, or until the expiry of the passport. So once the PGWP is expiring, let's say the PGW expires, most of the clients, they feel if they have a stamp in the passport, that gives them the eligibility to stay here.
Mm-hmm.
But that's one thing that I want to bring to the notice of all. I mean, if I am able to on my LinkedIn, on my Instagram, that I even have a video on my Instagram saying that this is not the scenario. You guys have to have some kind of extension application. The visa stamp does not give you a status.
Yeah. Like people think that they're automatically downgraded to visitor, but that they still are legally entitled to remain with that lesser status. I agree with that completely, Andrew.
I think another classic one and common one, which is sort of related, is that let's say someone applies for a PGWP or postgraduate work permit or any kind of work permit extension, and the work permit's extension is refused. It's not that the person now just can't work. It's generally that they are out of status. The two go hand in hand. IRCC doesn't say, well, your work permit is refused, so here's visitor status for the next month or two to sort yourself out. It's just, nope, someone's now without status in Canada.
The final one that I would like to mention, which I think in my practice is the most common one, is the various ways one can end up with a work permit extension or a study permit extension or a visitor extension refusal, even though the person has really done everything in their power to do that extension properly. I think for most people, it's really lost on them how complicated the extension process is. So just a couple of examples from my practice. You apply to extend your status and they say, yes, the fees have gone up. We need you to submit another $25. And so you log in, you go to the page, you upload the fee receipt, but they don't realize you also need to resubmit the entire application. Otherwise, even though you've bought the fee receipt from immigration, paid for it on one immigration portal, you need to upload it to a separate portal, upload it, and then resubmit the entire application. Unless you do all those things, the fee receipt, even though it might say received on the portal, it's not actually received until you've resubmitted the whole application. It's just not intuitive. And so that's another example. Other ones are people leaving, they have a valid work permit, don't realize they need a valid visa also in order to come back in. Like that disconnect between the visa and the permit is very confusing to a lot of people. Like there are just so many ways that people who are very well-intentioned or that they have a TRP and then they think that they don't need a TRP anymore because they've fixed the issue.
Oh, yeah.
And then like there are just
Yes,
so many
yes,
examples where people have even gotten advice and the advice was just wrong because even practitioners are not clear that if you came in and you didn't have the right visa, now you want to remain in Canada, you still need the TRP because there was a non-compliance previously. I could give a billion different examples, but like where you have three lawyers in the room and two of them say, no, you're good. And the other one is like, no, I don't think so. The policy and the law is very, very dense. And so there's a lot of what I would call accidental loss of status. And that's a significant portion of my practice right now, accidental loss of status cases.
Uh, Another one that I want my viewers to know is implied status. So someone's work permit expiring, they extend their stay as a worker or as a visitor, and during that period, they do another extension. So once the first extension application is refused, that time they're out of status. Most of the people think that because the second extension application is in, they are still on an implied status. So this is the area where most of people, when they come to me, they're like, oh no, our extension application, the second extension application was submitted before I got a refusal for my first extension application. But as per the guidelines, as soon as the first extension application is refused, there and then you become out of status. And most of the people, they don't know about it.
I thought in
Yeah,
that
the IRS.
case, it's not that you lose status, but you lose authorization to work. And so you can then subsequently lose status if you've worked without authorization. Like
Yes.
it's very
Oh, the
fraught.
guidelines have numerous scenarios.
Yeah. And again,
And
you
it's
have to
worth
read
reading them
them.
in detail if you're anywhere
Yes.
remotely near this scenario of like,
Mhm.
it depends a bit on when the second application was submitted,
Submitted,
vis-a-vis
yes.
the expiry of the document.
Exactly. That,
Yes.
what Steve just said.
And then, of course, regardless of what the guidelines and the law say, there's also the issue of like, does IRCC even know about that second application when they refuse the first one? And so you may get a
Yes.
letter that doesn't match what the circumstances actually are just because the visa officer may not be aware of the second
Yeah.
application.
Oh,
So
and
there's all sorts.
can I add to that one too? Like they might ask you for a document and they say, please upload it to the portal, but you can't because there's no upload slot on the portal. So
Yes.
you submit it by web form
Web
and then they
form.
refuse because they say they didn't receive it, even though you did send it and you can
Exactly.
provide proof that you sent it. So like,
Yeah.
again, I have lots of those cases as well. So
Point being, there are all sorts of ways due to the technicalities of the system and idiosyncrasies that someone who is doing their best to comply with the law might find themselves without status in Canada. So let's go to option one, which is restoration of status. This is the one that many, although not all, extension refusals will state. is that someone has the option to apply to restore their status. And Andrew, do you want to maybe just summarize sort of what the law on restoration is?
Yeah, so it's under Regulation 182 of the IRPR. It's like a person who's lost his status, he has 90 days to restore his status to a worker, visitor, or a student from the day he lost his status. So technically, I can restore my status even to a different temporary resident status. There's a lot of case law on this as well. So most of this people, they think that within 90 days, they're still in status. So they have 90 days to restore, but they think they're still in status, but that is not the case. So within 90 days after losing their status, they have to make an application to restore their status to either a visitor, a student, or a worker.
Yeah. And you touched on that. People may think that they're still in status during that period, but they aren't. So they can't study, they
They
can't
cannot.
work.
No.
One area that is sort of confusing is that ability to restore from visitor to worker or student to worker. And there's all sorts of mixed signals about this. What has your experience been?
I was talking about my case that was settled 3 days before the hearing. So this girl, she completed her studies and then she had to apply for a PGWP. But she got out of status. The IRCC guidelines say that if your study has been completed but you're out of status, you have to apply for a PGWP, and then you have to pay a study permit fee of 150, attach it with the application. Okay, so that clearly is the intent of IRCC, that if you have to restore your status, you can restore to a different temporary resident status as well. And most of the times people don't know that. Most of the people that come to me, they're like, no, my consultant or my agent told me that if I was on a student permit, I have to restore my status to a student. But that is not the case. Even there's a lot of case law that says that if you meet the conditions, initial conditions, you can restore your status to a different temporary resident status.
That's
Yeah.
very interesting that you say that, because I have heard DOJ say that you have to restore that status, like
Yes,
reading section 182 very literally. Maybe you
yes,
can sort of take us through some of the jurisprudence that says it doesn't
yes.
have to be that same status, that you can restore to a different type of status, provided that you still meet the conditions.
This case was 2018 FC 234. It's Grace Udodong v. MCI. At para 24, it says, but most importantly, perhaps, the case law on restoration strongly suggests that when an applicant is seeking to be reinstated in a different temporary resident class than the one in which he previously held the temporary resident status, meets the initial requirements of the stay of section 182, can reasonably be interpreted as referring to the initial requirements applicable to the class into which the applicant wishes to be reinstated rather than the class of TRS previously held.
Wow, that's amazing. That is a
Yeah.
really good tip.
Yes.
I'd say the jurisprudence on this is a hot mess because there are cases that also go the other way.
Okay.
And the main issue with the PGWP restorations is the whole. So for those who, just to backstep, it's people who graduated from their school, they apply for a postgraduate work permit online, which is the only way to apply for them now. That application is refused. Can they restore their status from student to worker?
Hmm.
So as Andrew was saying, there's at least one case out there which says that they have to basically restore to their initial status, which is student, and then also apply for the work permit. And
Yeah.
that's sort of what the guidelines say. A practical issue that arises, and which the jurisprudence struggles a bit with, is, well, to restore to student, do you need a letter of acceptance from a
Mhm.
designated learning institute, or can you put
Provincial
another document
attestation.
in? And the result is, um, I actually think it's the classic case of it. A lot of it depends on which judge you get if you're going
Yeah.
to federal court. I'm curious, like at the initial application stage, um, and I don't do a lot of restoration applications, but would you, Andrew or Deanna, include copies of the guidelines and highlight where it says that one can restore to postgraduate work permit. Because something, and I mean, in the ones that I've done, and I often do this, and we've talked about this on the podcast, where sometimes officers go against what the guidelines seem to say. And I wonder if it's because the individual officer may not be aware of this part of the IRCC guidelines.
I usually did not used to indicate anything about the guidelines, but since this case, I've started in my submission letter, I give footlet the hyperlink,
Yeah.
and I just in my submission letter, I tell them, okay, this is what it is, and this is what you are told to follow. So
Yeah.
I request you to follow these guidelines and provide my client with a PGWP.
Yeah, my answer is exactly the same. I never used to cite case law. I never used to cite policy or regs in my submissions because I felt like that was quite patronizing and that was not taken well by officers. But now I do. Sometimes I even print out the policy and include it as part of my submission with highlights and all of that. I don't know if it helps because some of them still end up going the wrong way, but I think in situations like this, anything that you can do to actually directly point them to the law or the policy that says this is something that you can do, I do. Especially with contentious situations like this, because a refusal is just so time consuming, so costly. And because I agree with you, Steve, that the jurisprudence is a hot mess, and I don't have the impression that it's a clear win. I did actually see a case not long ago, I can't remember what it was, where the officer who refused the transition from like the restoration application said that they should have applied to restore to a study bridging permit. I was like, what, pray tell, is a study bridging permit? Like, it sort of reminded me of those old live-in caregiver days where you used to have a bridging, remember, like you could just get a 3-month permit that didn't allow, it was a work permit, but it didn't allow you to work, but it was just to give you enough time to get an LMIA. It was sort of like, it sounded like that.
The
But
concurrent
like,
processing thing, or?
yeah, like just that they would give you, that you would restore to like a bridging study permit, which was not allowing you to study, but just gave you the permission to then get a new work permit for the
Yeah.
PGWP.
I
And
mean,
I
there's
was
a
like,
certain
this is a fiction.
unpredictability in this. Like I
I'll
had a
say.
client once come in they have tried to restore their status from, they wanted to go from visitor to worker, but they weren't sure that they could. So they just did visitor to visitor. And I kid you not, they had a recording of their call with an IRCC officer who called them to say, look, I know the guidelines imply and that our website says that you can't do this, but like, you never get what you don't ask for. I would have been totally happy to give you the work permit and you should have just asked.
Oh my
And
goodness.
it was really like, it was one of those eye-opening moments where like, I mean, that's one of those principles, right? You don't get what you don't ask for. So
Oh
like
my
it's very,
goodness.
but that's not something, don't take that as legal advice. That's just what this officer had actually said on the phone in this call that was recorded.
Apply for
Um,
something that the law doesn't permit us to do. We might just give it to you.
yeah. So what about, oh, go ahead.
Yeah, I mean, I wouldn't write that in my submissions at
No
all.
way.
Yeah.
You can just write, come on.
Yeah.
Please.
Yeah.
So during the period that one, say, applies for restoration, and this kind of gets to tour, and we can visit tour, what impact will that have on a permanent residence application? Like, can someone who has applied for restoration still apply for PR?
The thing is, technically, the officer was right that section 29, the applicant does not meet those conditions and the applicant is out of status. So the officer could refuse the application on that. But the thing is, if someone has not applied for restoration, even being in the 90-day period, then the refusal is justified. However, someone who's applied for a restoration, then the whole parliamentary intent comes into the picture that they have given the choice of applying for a restoration, and the officer should hold the decision on the permanent residence application until and unless we receive a decision on the restoration application. because
So you
once
think, but like, so when you say though that the officer technically is correct, it's interesting to hear you say that because it's like technically it's correct even if it's against the parliamentary intent.
I
Mhm.
mean, for someone who's not applied for a restoration application, because
Hmm.
it's contradictory. Rule 182 and these sections are contradictory to each other while the officer is giving this decision. Because officer is of the approach that yes, they're out of status, I can refuse this application. But then he has to consider sometimes, not sometimes, like all the times, that 182 is also into the picture. Then he has to consider that. Otherwise, 182 does not make any sense.
Hmm.
The officers are refusing the application even while 182 application isn't submitted. Then why regulation 182 then?
Yeah.
One of the favorite cases that I've ever argued was like probably the second one that ever had me in court. And I'm sure I've talked about it on the podcast before. It was the decision in Lim. And it was Mr. Justice von Finkenstein, who's not on the bench anymore, but he took a very pragmatic approach to the restoration provision and said that like the way that it says you've kind of broken the law, but you're still applying for relief through the regulations is a very kind of strange and nonsensical thing. So to have negative consequences arising from being out of status, even though you're still within the time that you can get this ameliorative relief, that he sort of talked about this in a very pragmatic and functional kind of way. And I just wish that that could be breathed back into the interpretation of restoration provisions, that if you're taking advantage of a provision that's meant to fix it and put you back
Yeah.
into the same
Yeah.
situation that you were before you lost status, the idea that negative consequences such as refusal of the permanent residency application can come about is just it's very mind-bending.
There's a jurisprudence 2014 FC 1086 at paragraph
What's the
22.
name of the case?
The name is, as you can, it's Abokar Lasseditor versus MCI,
Yeah.
PMCI. And at paragraph 22, the last three lines, it says, thus relying on the applicant's lack of valid status as a ground for exclusion is not consistent with the logic of a mechanism of restoration of status provided under section 1, rule 182. And then it says, in this regard, Justice Johann Gotthard noted, this would be contrary to the intention of the parliament.
Mm-hmm.
So, I mean, that's what my whole argument was based on. Like, what's the logic of restoration application then if
Yeah.
you are going to refuse other applications without considering the restoration application?
Yeah.
When would you advise, and this might be the way that the last question on restoration before we segue to TRPs, when would you advise restoration versus someone just leaving and trying to come back?
Oh, yeah, that's one option that I always give to my clients. Right now, I have a same client who's in the same position. The application has not been refused and he's still under the 90-day restoration period. And I've given him both the options. I've said, like, see, I can do a restoration. If the application is refused, then we'll have to go through a long process, go to the court, and you never know what the decision is going to be. If you want to go outside of the country, as soon as you go out of the country, you're not inadmissible.
Mm-hmm.
We can provide them with the proof that you have left Canada, and that could be beneficial for your permanent residence application. But then it totally depends on what the client wants. Does the client want to leave the country, or does he want to take a chance?
Mm-hmm. It's a very lawyery answer, but at the same time, it's the only way we can go right now. We have to be very, very strategic
Yeah,
because you need to balance things like what is the cost of doing a
cost of
judicial
living,
review?
yes.
What is the timeline? Like if you're here living in Vancouver or Toronto and spending at that kind of cost of living, funding a judicial review application, you might be out of status for a year and a half. I mean, who knows? I mean, maybe it's not that long for a restoration application. Maybe you're talking about 6, 8 months.
6, 8 months, yes.
Right now we're seeing almost 5 months, I think it is, for a regular extension. I always find restorations take about a month
Slower.
longer. And,
Mhm.
my partner Ryan Neely said yesterday that, they're adding 10 days to the processing time every week or so. So at this rate, by December, we're going to be talking about 6-month processing times. And and if that is true, you kind of just have to be practical. Like, let's just be realistic here. If we're talking about 6 to 8 months for a restoration application to come through, can you afford to be in Vancouver or Toronto or wherever you live,
Oh, yes.
paying Canadian rates, not earning any money? Or is it better for you to go outside of the country and apply to come back in? Now, keep in mind that when you apply to come back in, you're dealing with the fiasco of AI processed visa entry
Where
applications.
you've had a previous refusal and overstay indicated on the form.
Exactly, all of that. So it's a real balancing act. And I think it's more important now than ever before that it's not our job to say what is the best choice. It's
Yeah.
just to detail, here are the
Yeah.
pros and cons of each of them. Ask me any questions you want, and then you make the informed
Yeah.
choice. But
I mean,
that's how
Deanna
you practice
mentioned, you're
responsibly.
paying rent. If you leave, you're still probably paying rent unless you're
Yeah.
able to sublease your place.
Hmm.
And then you might be paying rent in two places.
Yeah,
It's a
exactly.
very, it's not an obvious decision.
Yeah, for sure. And if you lose your rent controlled place and then you come back and rent at a new starting rate, you might end up paying twice as much for the same rental property you've been living in. So there's a lot of factors, and it's
Lot
not
of
an easy
factors.
decision for people
Not
to
an
make.
easy. One more thing. So the bridging open work permit eligibility requirements, one of them is the applicant must be inside Canada, right? So if you are restoring with a BOWP, then the applicant has to be in Canada.
Hmm.
And it gives an option, BOWP, that if you're out of status, you can restore, right? So sometimes I think, because if the client is meeting all the eligibility requirements, then why not just do a restoration? Because we know that it is, I mean, we cannot be 100% that it is going to be approved, but if the client is meeting all the eligibility requirements, for me, it makes sense for the client to stay inside Canada and
Mhm.
eligible to restore.
Yeah, that's another factor for sure.
Certain
One,
applications can't be made from outside of
Yeah,
Canada.
it
So like
cannot.
bridging
Yes,
open work permit is one.
yes.
I don't know what about post-grad work permit. If you leave
no, they can be
the
out.
country, does
Well,
that put the
They
entire
can, no, they
they can
can
be
be out.
outside, but the study permit, oh, you can correct me if
study
I'm wrong
permit
on
is
this, but
like,
the study permit, I think, still has to be valid when they apply. And then by the time the extension was refused for the PGW, or the initial PGWP was refused, the study permit may be invalid. Long processing times really complicate
they
options.
sure do.
One other thing I guess we should touch on before TRPs is, what about if your extension is refused, your postgraduate work permit online, which technically is generally an extension, is refused, going to the border to restore your status at the border. Andrew, I see you like rolling your head or eyes.
I
Oh,
mean, if they have,
which port of entry?
I mean, if they sometimes, most of my clients, they're like, my employer is not going to let me work on an implied status. They want a work permit. Only then I can work with my employer.
Mhm.
So, but then the whole question is, do they have a stamp in their passport? Do they have a valid visitor visa to return to Canada? Because if they flagpole and they don't have a visa to come back, then they don't meet Section 20 then.
Yeah,
Then
I mean, if they're without status, that wouldn't.
yes.
Yeah, if they're without, I mean, generally the position that I've taken is, if you're from a country that lets people do initial applications on entry, Europe, Japan, etc., you may be able to just, depending on if you're eligible for the permit itself, the lack of status wouldn't prevent someone from just going to flagpole. If they're from a country which does require a visa, India, China, much more risky, if not allowed, and you're getting into like
Yeah.
positive officer discretion.
I I usually don't. advise my clients to go to the port of entry at all, because they have to go through a lot of questioning, and
Yeah.
sometimes it's not good for them to
Yeah,
go.
and it's also like which port of entry. There is a
Yes.
real, like, I mean, if you're talking about, going to a port of entry in Alberta or Montreal versus a port of entry in British Columbia, it's quite different.
Mhm.
Whether or not they have a US status document is different. Whether or not they require an appointment to
Hmm.
do a flag polling, whether or not they can go to the United States for a day or two so that they can come back and they don't require an appointment and it's truly a new application, how long they've overstayed, if it's 1 day or 3 months, because again, they're not applying for restoration at the port of entry, they're making a new application. And
Yeah.
so if they've overstayed for 3 months, then they'll be questioned about how did they support themselves during that time? Were they working without authorization? All of this kind of stuff. So I tend to be very conservative about this as well.
Yeah. And just to elaborate on what I was saying, like the basic, you're allowed to apply for a work permit at the port of entry, which can include flag polling, if generally in two circumstances. Either you're from a list of countries prescribed in the regulations that let people do that. That's generally thought of, I guess, as the Western countries, or if you were in Canada and you just go to the United States and back within the period authorized for your stay. So once you've had your extension refused, or even your initial permit refused or expired, that no longer applies. And so, for your person from China, India, it's more narrow when you can do that. Now,
and
anyways,
then we have to tip our
you
hats.
can't apply for a postgraduate work permit at the border anyways. So
Yes,
Yeah.
that's the
People
reality.
do it all the time, but it's a mistake if they issue it. So people
Yeah,
do it all the
so
time.
I've met people who've gone to the port of entry even after the instructions that PGWP is not allowed to be submitted on a port of entry now, but most of the people they do go, and sometimes they do get a
Mhm.
PGWP for 3 years.
That's what I hear too. Yeah. But again, I don't ever recommend it when it's not
No,
actually something that they're legally entitled to do. It's the
I
same
know.
as like, yeah.
okay, so restoration, done within 90 days, generally, I mean, it's the difference between restoration and temporary resident permit is restoration 90 days after someone's status expires, they're eligible to apply for it. Then after that, the only real option to get temporary resident status back is something called a temporary resident permit, not to be confused with a temporary resident visa. A temporary resident permit is a specific document for someone who is basically ineligible to be in Canada or doesn't meet the requirements of the act. They can get this permit. Um, what is do either of you want to speak about just the test for a temporary resident permit and what is different about it from, say, just a restoration application?
Diana, you take the lead on this one.
Yeah, sure. I'm happy to. I wish they still called it a minister's permit. That's what it used to be.
It
And
would
it
be a
would be
lot simpler.
less confusing and it would sort of more speak to the intent of a minister's permit of what the TRP is. But essentially, a temporary residence permit is a document that will enable you to remain in Canada, where your need to remain in Canada, like you have to be either ineligible or inadmissible to Canada. So meaning that you can't meet the requirements of the regulations or that you're somehow inadmissible based on one of the admissibility provisions. And your need to remain in Canada is greater than the risk to Canada of allowing your admission. So that's the basic test that they look at. They do kind of a balancing. If you are given a TRP of greater than 6 months, you can also apply for an open work permit that goes with that temporary residence permit. So I can't remember what section the TRP, but basically the authority to grant TRPs is under 24 of the Act. And then I can't remember what the provision is under the regulations. Maybe somebody will remind me
Yeah.
as to where you get the work permit that goes along with the TRP.
So the big difference would, I mean, there's a few, but one of the big ones would be restoration. There's no real special test. TRP requires essentially that there be a compelling purpose.
Mm-hmm. So like with a TRP, like there are situations where you'll be applying for a TRP because you do meet the requirements of like you're in status. However, you are criminally inadmissible because you have a DUI. So they'll grant you the work permit, but the TRP kind of overcomes the fact that you would otherwise be inadmissible. So it sort of allows you to get the work permit in spite of the inadmissibility for the duration of that work permit. So it's kind of like a Band-Aid solution for the duration of that work permit that overcomes the admissibility. But it can be dealt with in a situation where you've lost status beyond 90 days. You're at that point ineligible to apply for a work permit because you're now barred by the restoration provision. You can't apply for a new work permit. But if they grant you a TRP, then you can enter Canada on the TRP and you can get an open permit that goes with it if the TRP is granted for 6 months or longer. The important thing about TRPs is they don't like giving them. And part of the reason they don't like giving them is because if you get a TRP, they're not supposed to unreasonably deny extensions of the TRP if the circumstances that warranted the initial TRP are still there. And if you're on TRPs for long enough, you would qualify for permanent residency and what's called the permit holders class. Again, I don't remember what section that is, but it's sort of like when they're issuing it, they're like, is there truly a compelling need? They know they're kind of opening up a pathway to permanent residence without the CRS score, without the express entry. So they want to be very judicious in when they issue these because it's kind of, they see it as a kind of break, like, jumping the queue, I would say. And
Yeah.
so they're
They would never
very,
put that as the refusal reason, but the
in
suspicion is
reality,
that there's a reluctance to issue these both because of the open work permit tie-in, as well as Deanna was mentioning, there is actually a dedicated permit holder class
yeah,
where if someone's been here three
Yeah.
to 5 years, I think, depending on the inadmissibility, then
that
there's a pathway to permanent residence that doesn't exist for people, say, who never
exactly.
lost their status.
Exactly. They don't want to put you in a better position than somebody who didn't lose their status. And so again, I understand that and that makes sense. But it does mean that they're very hard to get. It's not just like, hey, I lost status. It's unfortunate. Can I get a TRP? It tends to be it takes a fight to convince them that the need overcomes the risk.
Do you view them as mini humanitarian and compassionate applications?
They are humanitarian and compassionate applications on a temporary basis. They're just the temporary version of an agency. And in fact, the need versus risk as compared to are there humanitarian and compassionate grounds, to me, they're kind of like a different articulation of the same, like, do we think your circumstances overall warrant a compassionate response? I think that in reality, they're fairly indistinguishable.
Okay. One question. I've never heard of a TRP with a multiple entry. I have never
I've
seen.
seen them before,
Oh yeah.
but they're very, very hard to get.
At the port of entry is where you'll get them more. So like if someone say again the American with the DUI who
Mhm.
it doesn't say explicitly that it's multiple entry. It says exiting Canada does not invalidate this
Exactly.
Okay.
TRP.
All
I'm
right.
not,
They're kind of a unicorn though. They're coming less and less, which is annoying.
yeah, I'm not aware of Edmund like inland offices issuing them as much for sure. Um, but where there's more business travelers, say, who's going back and forth, that's when you'll see that notation printed.
Mhm. I used to be able to get them for caregivers where they were accompanying their employer, but for some
Okay.
reason it always has to be related to some business need as opposed to just like, I have sick family members that I need to go back and visit. I don't know.
What's the processing time?
How long is a piece of string?
I recently did a TRP and it took around how, 12 months?
12
Yeah.
months?
12 months,
Yeah.
Yeah.
yes. It took 12
So
months.
that is a long time for someone to be in the country without status, kind of the same as restoration. When do you advise, and the same question sort of as earlier, when do you advise someone to leave and try to re-enter from abroad versus applying for a TRP?
Wow. Um, then it again comes down to the factors that Diana told in restoration, right? How much cost and benefit analysis? How much is
Mhm.
one willing to
Yeah.
spend in? How much is one willing to go back? And
This
then,
time too, the likelihood of readmission may be less because
yes, yes.
there has been a much longer overstay often than just the 90 days, let alone
Mhm.
any other
Yeah.
inadmissibilities.
And
Yeah.
then the breach.
I would say for a standalone TRP, like I mean, we do TRPs all the time when it's like somebody's criminally inadmissible and they're trying to get a TRP to overcome that inadmissibility. Those are quite routine, strangely. But when it's this TRP just because somebody's lost status, I would say I only really ever do those when I'm also doing an agency. And really, the prospect of returning to the country of citizenship is not viable. And it's kind of like a last Hail Mary attempt. You throw everything at it. You do an agency, you do a TRP, and then they wait. And if it's refused, then that's kind of like their last shot. Um, but again, I think that my perspective on these, I used to have a much clearer gut instinct as to what was a viable TRPs plus H&C. Now, with the numbers having been so drastically cut, and this, goes back to the episode that we recorded a couple weeks ago, Steve, I've lost my sense of what is a viable H&C because, I mean, a third of the cases are going to be accepted as compared to previous years, as sort of my sense of it, based on the increased volume that we're likely to see. So it's harder now to predict like facts that I think would have been compelling facts that would have led to a successful application in the past. I don't know anymore. And so it's a really hard time to make that call. But I think ultimately I think people need to be aware. Like I just think that the likelihood of approval is always going to be very low, and I think never more so than right now.
What are you seeing? So like this kind of ties in a bit to an episode or two episodes ago, we talked about the immigration levels plan, where the department expects 1 to 2 million or is planning on 1 to 2 million temporary residents leaving Canada. I don't know what the situation is in Brampton, but in Vancouver, it's no longer possible as of today, I think, to get an LMIA where the wage is less than about $34. Um, and a lot of people who have applied to extend their status may not be able to, and there may be this big uptick in TRP applications or restoration applications needing to be made. What are you seeing in Brampton?
It's the same here.
The same prohibition, the unemployment rate's
Same
above 6%. So the
6%.
yeah,
And but you know what? I'm not totally a fan of LMIAs in Brampton because most of them are like fraudulent. They're sold. So I'm not a big fan of LMIAs, but I have certain clients who are like 2.5 or 3 hours from Brampton, and they genuinely need cooks. So I advertised the job, and this guy did not receive even one resume.
yeah,
So, and one of his employees, his work permit expired, and he hasn't still got an LMIA. So there are people who are suffering as well, but with Brampton, I am not a big fan, and because the unemployment rate is 6% and more,
yeah.
it
So
means
are you though in that expecting there to be this uptick in people who are starting to fall out of status?
yes.
And the sense that you're getting is like, do you think people will leave? Will they apply for TRPs?
So mostly what's happening over here is like if there are a couple, they apply for open work permits through common law, or they get married to each other if they're in a genuine relationship. Some of them are applying for a visitor record just to maintain their legal status. Some of them are trying to move to different provinces just to see what they can do over there. But then I always tell them, even if you're moving to a different province, you need to have a legal status. It doesn't mean if you can move to a different province, you can just be there like without a legal status.
Yeah,
I mean, there's a lot of desperation out there right now.
Yes,
There's
it
no
is.
doubt. I think every practitioner across Canada, I know that the lawyers from my firm who are doing a work permit or permanent residence-based practice are saying that there's nothing more just depressing than doing consultations right now. Because, so many people with genuine, hard-earned pathways to permanent residence are getting close to the end of their work permits. They've done nothing wrong. They've done everything right in compliance with the law, and they're just running out of track. Is there anything I can do? And our lawyers are lining up and saying, I'm sorry, no. I know I have a tendency toward the alarmist. We're hearing about in the United States mass deportations. We're not talking about that in Canada, but what we're saying is, a huge quantity of people are going to end up with no viable way to extend their status.
Yeah.
We're not
Plan.
talking about it in
That's the
terms
plan.
of, that is the plan, that is the
Yeah.
formula. And so while we're not talking about it in terms of mass deportations at this time, we are saying that we are expecting those people to just pick up their lives in spite of the investments they've made into their Canadian education, their Canadian employment, the fact that their children have grown up here or being, born here, that they're really going to have no alternative but to get up and go. And, I understand there is a huge uptick in fraud. And I don't think that I think there's quite a bit of consensus that people that are defrauding the system should be leaving. And we don't have a ton of sympathy around that. But even with that, a lot of cases, it's because they're actually fleeing something quite genuine. And, but yeah, I think that this deluge that is coming upon us is not just coming up from the US across the border. It's coming from within our own ranks, people that came in through proper channels and are now running out of track, as I said.
Yeah. We'll be polite about it though. It's the Canadian way. Our
Yeah.
letters will continue to say we are refusing you and throwing you out of status and you're not allowed to work. And thank you for the interest that you've shown in
Yeah.
Canada.
Yeah, but I mean, I think I want to kind of call bullshit on the polite too, because people call me and they're like, I just got a deportation order in the mail. And I was like, does it say on the top voluntary departure notice? Yes, it does. Like people don't understand the difference between a voluntary departure notice and a deport order. And so, um, it might sound nicer to somebody who understands the difference, but when you get something in the mail that after 7 years and you've done all this stuff, you've made your life in Canada, you get something saying, thank you very much, we'd like for you to go home now. There's no effective difference to that person that this is a deportation order in their minds. Effectively, they have to now wrap up their life and go back to a country that they had effectively moved away from.
But I feel majority of people that I meet, they're not going to go back. Majority of clients, I tell them you have to go back once you don't have a legal status. But the irony is most of them they won't, because in their head they're like, we've spent more than half of our investment, time, cost, everything is involved. What am I
Yeah.
going to go back and do? I mean,
Yeah. And I mean, things are really I don't know if the majority of your clients right now are coming from India, but things are pretty complicated there. It's sort of you know, off you go. We don't need you anymore, go back. And there's so many countries right now where people who have become part of the Canadian community are now being told thanks, but no thanks.
yes.
It's not like they have options to just go back and set things up. So I think that the lack of empathy for that, I find very troubling. And while everybody's wanting to talk so much about the situation that's happening south of the border, I'm very concerned and perturbed by where we're at. What's going to happen to those? Because I think you're spot on, Andrew. I think that a lot of people just will say no. And so this idea of the mass deportations, I don't think that we're going to be far behind on that.
If we
I
have
don't know.
even the state capacity to do that. I mean, it's going to
Yeah,
be
I know.
interesting because if, there was talk 6 months ago about doing some program to regularize the status of undocumented people. And there were estimates that that would range from 50,000 to, I think, 500,000 was the absolute peak of how many people that could be. If the immigration levels plan actually goes as planned, then in 2 to 3 years, and the people don't leave, you could have this weird scenario where like Canada's a country of 40 million people with 2 million undocumented, 5%.
All of a sudden, yeah,
Yeah,
exactly.
so we shall see.
Yeah, but like, I mean, I don't know, like, I don't think that we are, like, there's no indication from either party that we are moving toward regularization of those undocumented workers. Every indication, multi-party right now, is that no, we are moving towards a no tolerance. Um, and in fact, I mean, I've sort of, I, especially after we saw what we have seen in the United States, like, I don't think that we are moving toward another term of a liberal government. I believe that we are going in a more conservative direction. Um, so yeah, I do feel quite frightened about whether or not they're, because like, if there's less resources being spent on processing, I understand what you're saying about state capacity to conduct those removals, but those state resources that are currently being spent on judicial review applications, on I mean, obviously not on judicial review, that's a totally different thing, but like on processing, if those are rededicated to enforcement, like I just don't know. I mean, I am sounding the alarm bell here. I feel like I think it's appropriate. I think that we're really I think we need to sort of, like, what is gonna happen? What is gonna happen when those work permits run out and there's no intention to renew and people just say, no, sorry, I'm not going back.
Yes. I
What's
mean,
the plan?
my clients, most of them, they're trying something. I mean, I feel bad when they come to me, and usually I had so many options for them, and now it's been restricted to a few options, and I don't have an answer to them.
Mhm,
How do you renew it? How do you, because renew it, yes, you need a job offer, government approved LMIA job offer, yes, but now that is also restricted. So
mhm.
I don't know what to tell to them, but by the end of the day, I am of the opinion most of them they're not gonna leave.
Yeah, no, I don't think you're wrong, Andrew. And I think that, like, how do you create an unfixable rift in society is by disenfranchising such a huge community that was at some point welcomed. And now you're like, sorry, I don't
Yeah.
know. I mean, I feel like, um,
I've tried to browse and find examples of like countries throughout history that have tried to like reduce population outside of like war zones or genocides or things like that. And the United States muses about it. That's different from here because that, is for undocumented people. And there aren't very many examples that I could find of countries that tried to reduce population of people who are legally in a country. The only one that came up, and I want to read more about it, but I don't think it's come in yet, is Saudi Arabia tried through or is trying through Saudiization. Um, but yeah, it's
mm.
going to be interesting.
But I do think that that's not an inappropriate parallel, because I don't think it's just about reducing population. I think it's also just about creating an underclass. I think it's more about that, where it's like, I mean, it's really essentially creating a two class system. Some like, come on in, but we don't intend to incorporate you within our society. And I think that, like, in Saudi, like, you can live there for, your entire life. You can even be born there, but never actually be part of the society. And Canada has not had that. We have the sui generis kind of policy around citizenship. You're born here, you are from here. But again, when it comes to permanent residency, it's sort of like it used to be the case that, you would come and you had the ability to earn permanence. But I feel like when we disconnected the temporary from the permanent, and some people were just never going to become part of this place, again, it's sort of like it leads to a very different philosophy where and this is what I'm seeing so much about the US election, like this idea of individual rights over collective rights, you know? And if you're never part of the collective, it's the creation of this underclass, this idea that like you're here and we're going to use you as we need you, and then when we don't need you anymore, then we expect you to leave. But
Yeah, I mean,
those,
I don't think it was the original plan. I think we've kind of stumbled into this.
I don't know. I don't know, because I remember distinctly, Steve, that when we talked about these things and the massive growth of the temporary foreign worker program, and I've said this before, when I was the chair of the CBA and we were talking about this at the policy level. Sorry, my dog's gonna freak out. No, she's good. We were talking about this. Um, you know, we were talking about the actual risk of creating an underclass, and we had speakers coming in about this happened in Europe, this happened in Australia, let's not do the same thing. These were active conversations. And then in
Oh
spite
no,
of
I'm just saying
that,
I think I'm not saying that the stumbling was super short term. I think they thought that they would give them all PR.
yeah,
I think
That's what I
that
thought
yeah.
when there was a program
that's what
TR
they
to
told
PR.
them.
Yes, TR
That's
to
what they
PR.
told them.
I thought they're gonna do TR to PR for these group of people as well. But now I feel it's biased because some people who just studied completed their studies and they became PRs. But now there are a group of people who studied, worked inside Canada, and now they have been
Yeah,
working for
I think
years, and now they're being asked to go out.
Yeah. Yeah, it
what
turned out to be a lie, I think,
Yeah.
is what is causing this anger and like volatility.
let's switch gears completely. And sorry, I completely forgot your name sitting with Andrew.
Ajay.
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 Ajay, what are your thoughts so far? You've just started practicing immigration law. You're coming into it at a weird time.
Yes.
Mhm.
What are you enjoying it? What
So, I wanted to add something on this topic that it is becoming difficult for people who are on temporary status in Canada and getting their permanent residency. But few of our clients have been taking the hard choice of going back to their home country and gaining that foreign experience again to target some of the permanent residency options, some of the express entry or PNP options, and then coming back as a PR, gaining their relevant experience. I think that is a very viable option for people who are inside Canada and then they're searching for options to extend their temporary status rather than going back to their home country, spending some time with the family as well. And in the meantime, gaining that foreign experience to come back with that CRS points and everything. And then,
yeah.
uh,
What made you choose immigration law?
so when I started
Why would
practicing,
you join this? No,
When I came from India, I was an immigrant as well. I was on a study permit, and then I started working with Andrew. I had a few consultations with him with some clients, and when I looked at the immigration situation, it really motivated me. Like how I went through the temporary resident permits to a permanent residency, and that is the main reason that it in gain uh, what you say. I mean, I was very interested in helping people out to gain that permanent residency. And yes, the journey
Can I
began.
ask when you moved to Canada?
I moved in 2021.
So it's pretty recent. I'm just like, because the topic you're starting to see in the news and the media is whether Canada itself has been a bit of a letdown to a lot of recent migrants. And, I mean, I assume you like your job with your boss sitting next
But
to you and everything, but like amongst your cohort, like of just people who came at around the same time, like what are people's sentiments?
I was of the very same opinion if you would have asked me after 1 year when I came to Canada, because I was a lawyer back home as well. I practiced law back home for 2 years. Then I moved to Canada, and after 1 year, I wasn't getting any jobs here. Not even the basic level jobs to start in an office. When I met Andrew, that was when my uh, uh, job and my dream started. But yes, if you haven't asked me 1 year down the line after coming to Canada, the situation that was shown to us when we were back home, that how Canada is and how the job market is over there, it was not the same when we came here. And most
That's,
of my
sorry,
uh,
go ahead, Andrew. Ajay.
many of my colleagues who came after me, they came here, they studied, but they eventually decided to go back and practice law in their home country because they were eventually not able to find jobs here.
Mhm.
That is the whole. issue that was, and that is right now as well.
Yeah, we recently did an episode with Alice Craft from the Conference Board of Canada, who talked about difficulties that recent permanent residents face, and things that employers can do to help. Like, how did you, I mean, this is getting a bit personal, but like, how did you meet Andrew? Like, what was that by chance? Was that,
So I was when I came to Canada, I was doing a paralegal co-op with a paralegal program at Georgian College, and then through that course, I got into a co-op position in the firm, and that is how I met Andrew, and then my journey started now in
nice?
Canada.
I think that I was going to just do the same thing, Steve, and plug the Alice Craft episode. I think it got a little bit buried because we had done the, Minister Kenny episode, and then we did the announcement about the cuts. It was a really, really insightful episode, and I think it had a lot to say about um, about the stigma that a lot of newcomers face and how this whole thing about needing Canadian work experience, where this notion comes from and what the pushback is for newcomers to Canada, and the sort of hesitancy that a lot of Canadian employers have to actually leverage the talent that's coming into Canada, which it sort of puts in it explains why, like, Canada always looks at outcome measurements for skilled workers, but I think it doesn't take into consideration when it's looking at those outcome measurements what the barriers are to successful integration. And I think they'll say, well, people from this cohort of skilled workers aren't successfully integrated, but the question to me is always why. And I think Alice Craft in her paper really did that. It's because there's a reluctance to actually leverage that expertise that's being gained outside of the country. And there's this notion that, like, the Canadian way is the correct way, rather than just saying, tell me what your strategies are that you're using and bring those. Like, that's great insight for us. Finding best practices from other places. I think Canada has a real reluctance to kind of really gain that insight. And so I think that that's part of what is being, to me, the downfall of the skilled worker, this kind of human capital model, is that it's supposed to be like finding people to fill in gaps in the existing Canadian labor market without trying to, like, gain insights that are actually that have been developed elsewhere. Like, we don't necessarily know the best way to do everything. Let's try learning from global leaders, and actually gain the expertise from global leaders. And anyways, I think that her study was really excellent at trying to highlight the best ways to do that.
Diana, I would like to add that when I came in 2016, and when I came, I had already taken my NC exams in India, and bar exam was left and the articling was left. So I dropped in resumes to a lot of firms, but then one day I got lucky, and I articled with Mr. Jeremiah Eastman. So his paralegal was leaving that day, and I just dropped in my resume.
Wow.
That was a lucky day, and he asked me, when can I join? I said, I need an article. I can join like tomorrow if you want. And then it went through, and he gave me a chance, and I'm really thankful to him that he took a chance for someone not with a Canadian experience, but someone who had experience back home. It was difficult
awesome
to get into an articling position, but then I think I got lucky that day.
Yeah. Well, I mean, two of the associates of my firm have gone through the NCA process, and they approach things in a very different way from what I do. And I have, like, greatly benefited from the insight that they bring, because it's always extremely eye-opening. And I think, I've just, like, anyways, I've said it already, I've just benefited so much from just a unique perspective on how to practice, and even coming from a civil law practice and then entering like, it's brilliant. It's so great to have, especially when you're working in immigration, because their ability to, like, look at statutes and interpret them in a way that is just really not my thing. It's extremely helpful, so yeah.
Guys, I know
this
this is not the topic of discussion, but I just wanted to ask,
Oh no, we always go wherever the wind
immigration
blows us.
allows people, like consultants as well. I mean, I don't want to demean any profession. There are very nice consultants as well, but
Yeah,
there are
for
good
sure.
agents as well, right? So we are competing with them as well. So
Yeah.
whenever a client comes to me and I say, okay, this is how much I'm gonna cost. This is how much it's gonna cost you, and they're like, oh no, that consultant is doing for 250.
Is what?
250. Something if I'm charging 1,000, the consultant does it for 250, or the host
Yeah,
agent
yeah.
250. And then I feel like, see, it's the quality of work as well. You're getting
Mm-hmm.
something that from a lawyer. I'm going to spend my time on that. But if you feel this is the worth of it, you can get it done from a consultant.
Mm-hmm.
And I think IRCC on its website, they say that you don't need a lawyer or a representative to do your application. I am so totally against that line on
Yeah.
the IRCC
Mhm.
I mean,
website.
I wish that were true from an access to justice standpoint. I wish it were true that people could navigate the system on their own. I do not believe that's true right now.
No, that's not.
I think it's unfair that people can't do this on their own, but they've made the system so incredibly convoluted that trying to do it, you're kind of acting against your own interests a lot of the time. It's incredibly hard to work this. And I mean, I think Steve and I are pretty united in the fact that we don't take a strong stance about consultants. I think that there's so much work out there right now that you know, whoever's going to do the work in an ethical way and you know, providing a good service to their clients, you know, price it as the amount of labor is appropriate, but like
Yeah, my first paper and lowest marked paper in law school was that I thought that law school was an unethical barrier to practicing law. So I'm not the right person to be
yeah, I don't
yeah,
know. I'm
I
an
mean
access
my
to
my
justice
perspective is
person.
almost,
Yeah,
I guess on the extreme libertarian side.
yeah,
I mean, I
I'm
think
Then
not
it's
people
far
who have
off.
issues can go
because
see that.
of IRCC stance on this. A lot of people, they become victims of fraud because of IRCC. Yesterday, I got a client. He received a procedural fairness letter. He said he got his file done from a ghost agent, and the
Mhm.
IRCC now got to know that he used that ghost agent, and now they're sending
Yeah,
a procedural fairness letter to the client stating that you used and authorized, and
yeah.
the agent made the GCK account of the applicant itself. So
Yeah, I know. I agree with you. I mean, it's to me, there's no culpability on behalf of the department. When you make a system that is so convoluted and so complex that people can't afford my rate. And again, I can't operate at a lower rate, so I don't make any apologies for that. Operating and running an office in downtown Vancouver is not at all
Yeah, I
easy.
mean, like, again, someone in Chandigarh, Lagos, Beijing should not. The idea that they would know what an authorized and unauthorized representative is and a continent away when they submit their application is, to me, ridiculous.
And that you're going to penalize them for
Yeah, I've
relying on an
applied to
expert. Like,
visas to certain countries, walking into a travel agency. Pretty sure when I went to Dubai, it was through the Emirates website, Emirates
yeah,
Airlines website. Like, I have no idea if they're authorized or not. It would not have occurred to me that this would even be an issue.
no,
I
100%.
think it's
Yeah, it's a very punitive
I guess,
system that we've got. It really is
seriously,
truly punitive. And again, you shouldn't, to me, you shouldn't have to pay thousands of dollars in legal fees to make a TRV application. That just shouldn't, like I'm saying that I believe if you're doing it responsibly, that is kind of,
yeah.
you know, but
I
it's
mean,
just,
Andrew kind of like, and this ties it all together. Andrew gave that example of, or maybe it was you, Deanna, of the whole how you have to know to upload a document to the IRCC website. I think it was Deanna, that then transmit it.
yeah,
And if not, I've met
you're
people
screwed.
who are
Yeah,
thrown without status who can't work because they
yeah,
didn't know that uploading it wasn't enough. You had to then do the transmit button,
yeah.
which
And they'll
makes,
say,
when you're
but the
doing it, it makes it
instructions
look
are
like
on
you
the
have to
website.
repay. Yeah, yeah.
Yeah,
Like,
yeah. It's not at
so,
all intuitive. And so I'm trying to make the argument in federal court because I have one that's going through federal court right now that that is not procedurally fair. Like when you need to read tens of pages of instructions and not an intuitive system, that is not procedurally fair. But again, I don't know if the court is going to go with me. It depends very much who's going to be sitting on that day. And oddly, I had two cases. One of them settled before I even perfected leave, and the other one I'm waiting for. I just got a production order. So like again, even that in inequity and like the costs differential, there's no explanation for
Yeah.
why one of those clients is, so yeah, it's quite a mess.
Yeah.
Steve,
This has been fun.
Yeah, it
talking
has
It's
been
been
fun.
fun.
Chandigarh,
Yeah.
just last thing, talking about
Yeah.
Chandigarh,
Yeah.
I remember I went to I studied my law in Chandigarh. So when I was applying for a visitor visa because they refused my study permit, I had a CLB 9, and the refusal was you don't meet the language abilities. I was
What?
I was like, okay, that's fine. And then I applied for a visitor visa. And I cannot tell you, I went to an agent was just sitting there and he was like, okay, have you ever been refused? Have you? I mean, I was a lawyer. I knew my applications were refused, and I told him that yes, it has been refused. And that's why it's in my record, there's a reason. But someone from coming from not an educated background and talking to that person the way that person was talking, he would definitely not be able to tell that yes, he was refused before or no, and then that person would be liable for a 5-year misrepresentation.
Yeah.
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 That's
Oh, there's so many examples of how
Oh my
unfair
God,
and
there's
like
so many. Not to
Okay.
mention an administrative decision or whatever the one was that we talked to Andrew Hayes about where anyways,
Yeah. We'll have to have you on again soon to do H and C's because we didn't
yeah.
have time to get to it today, but this has been fun.
Hmm.
And yeah, for both of you.
Yeah.
Um,
Yeah.
yeah, thank you for coming on.
Yeah,
You're
definitely.
welcome.
That
You're
was a real
welcome.
fun chat.